Hello and welcome to my podcast Think Like a Lawyer. In this episode, we'll discuss what we term as an occupier's liability. Stay tuned. My name is Angela Sido. A company or individual who occupies a property has duty of care to the people who visit it. Occupiers' liability is the area of law which deals with this duty of care, and it applies to anyone who owns or rents a property that people can visit. An occupier has a duty of care to all visitors to ensure the premises are reasonably safe. This is unless the occupier is aware of a specific danger, in which case they must highlight this danger. This duty of care applies to anyone who's visiting the premises legally, such as visiting member of the public or a post worker delivering letters, etc. If a child is visiting the premises, the occupier must take additional steps to take care of their safety because children can be less careful than adults. The occupier doesn't have a legal duty of care for the safety of a trespasser unless there are dangers that the occupier is or should be aware of. If there are any dangers on the premises, the occupier should take steps to make any visitor aware of these dangers. If they don't and someone is injured, the occupier could be blamed even if the injured person didn't have the occupier's permission to visit the property. If someone does suffer injury because of an accident on the premises, they may be able to make an occupier's liability claim for compensation. Now, what types of premises are included under the Occupiers Liability Act? Occupiers Liability Law relates to public places such as shopping malls, department stores, car parks, museums, hospitals, parks, restaurants, and private residences. These claims relate to the duty of care of property owners and anyone who has some control over the premises where the accident happened. When you are out and about in public, you are legally entitled to be able to enjoy public spaces without facing unreasonable risk to your health or safety. It is the duty of the occupier to ensure that this is the case. So, for example, shopping malls are usually managed by a company. This company would be responsible for ensuring that the mall is safe for shoppers. Individual shop units may then fall under the responsibility of the owner of that shop. The occupier is then responsible for managing the risk in that environment, from ensuring the plumbing and wiring meets the necessary safety standards, right through to cleaning up spillages that could pose a slip hazard. Hospitals are also covered under Occupiers Liability Law. If you are a visitor to a hospital, the occupier of the hospital must ensure that the hospital premises are reasonably safe for you. If you slip on a highly polished or recently mopped floor and are injured, you may be able to claim compensation against the occupiers of the hospital for your injuries. If someone makes an occupier's liability claim during the case, the courts will consider whether the occupier breached their duty of care. Just because an accident has happened, it doesn't necessarily mean the occupier neglected their duties. In a recent case, a man was injured when he slipped on ice on an unmanned car park owned by the local council. He brought a claim against the council on the basis that they should have gritted the car park when ice was forecast. The council didn't have a proactive system of gritting the car park, but relied on members of the public to report snow or ice before sending out a gritty broom. The injured man lost his case. The court compared the cost of proactively gritting the car park when ice or snow was forecast to the risk of someone slipping and being injured. They found that the cost of proactive gritting would have disproportionately expensive, so they concluded that the council had taken reasonable care to protect visitors to the car park with their policy of reactive gritting. Although this individual lost his claim against the council, There are many examples of injured people winning their claims after being involved in an accident in a public place as a result of the failure of the occupier to ensure that the premises were safe for visitors. A landlord's liability to a tenant for the state and condition of premises is generally determined by the terms of the tenancy. A landlord will not be held liable under the Occupiers Liability Act 1957 for injuries sustained as a result of defects that the landlord was under a duty to repair under the terms of the lease. A landlord which lets premises to a tenant gives up control of the property and is not, therefore, an occupier. However, even where the landlord has given up the effective control of the premises, it may retain control of any common parts, example staircase, roof in a block of flats, and will therefore be an occupier in respect of those areas. Accidents at work and occupiers' liability. An accident at work doesn't fall under occupiers' liability. This would instead fall under employers' liability. Under employers' liability law, an employer has a duty of care to provide their workers with a safe place to work. This means ensuring that their work processes are safe, they have well-maintained and appropriate tools and equipment to carry out their work, and that their fellow workers are competent. If a worker is working in any way from their employer's place of work, their employer has a duty to ensure that the workplace is reasonably safe for their employees. If they don't and the worker is injured, the employer could be found to blame. What are some of the defenses available to an occupier? 1. Contributory negligence. The occupier may allege that the visitor's injuries were caused or contributed by their own actions under the Negligence Act. An occupier is not under an obligation to a visitor in respect of risk willingly accepted by the visitor. It is not therefore under a duty to a visitor for self-inflicted injuries that they sustained when they voluntarily took risk in the face of obvious warnings. Occupiers can discharge their common law duty of care by properly warning visitors of potential dangers. The court will consider whether it was reasonable in the circumstances to provide a warning and whether the warning enabled the visitor to be safe. When applying this reasonableness test, the court will take into account the extent of the warning given as against the level of danger. Also, an occupier can extend, restrict, modify, or exclude their liability under the Occupiers Liability Act 1957. This defense is not available to business occupiers, as the Unfair Contract Terms Act 1977 prohibits exclusion or restriction of liability for death or personal injury resulting from negligence.